The next case before us is In Re NB. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. May it please the Court, Andrew Karras on behalf of Appellant Amanda Weatherholt. I'd ask to reserve 5 minutes for rebuttal.
Thank you.
We have raised 3 questions in this case. One is every task recorded in a comprehensive health history regularly conducted such that it qualifies under the business records exception to the hearsay rule. 2 is the use of powdered rather than liquid formula, appropriate fodder for a dependency determination. And 3, does the caseworker undertake reasonable efforts to prevent removal of a child by making a few phone calls, absent testimony, describing what happened in those phone calls and what other efforts were made. I'm primarily planning to talk about assignments of error 1 and 2. I'm happy to field questions about the reasonable efforts issue as the panel might have them. But to start with the evidentiary issue, the admission of the hospital records in this case, primarily I would submit that where the trial court went wrong in this case is flattening the difference between Revised Code 2317.422, which is an authentication rule, and the requirements in Evidence Rule 8036, the business records exception to hearsay. Again, as described in the terms of the statute and the cases that have construed it, the statute is about authentication. It's not about admissibility. And so in order to be entered into evidence pursuant to the procedure outlined in the statute, there does need to be some demonstration of an applicable hearsay exception. And to be clear, the requirements in the statute and the hearsay rule aren't entirely uniform. So under both the statute and 8036, to qualify as a regularly recorded activity, the record, as a matter of record keeping, has to be regularly recorded. But also, under the rule, and not the statute, what is described in the record as a matter of business practice has to be some sort of primary activity that reflects the ordinary work of the institution. And so here, certainly the attestation page on the front of mom and baby's medical records fulfill the requirements of the statute and that first prong of 8036, but not the second. There's, for instance, nothing in the testimony. There's no other evidence that, for instance, is as part of their ordinary work, moms stop dads from absconding with babies. Maybe that is the case, maybe it isn't, but there's nothing in the record reflecting it.
Let me ask you in regard to that. So I understand your argument about the medical records. What was the actual testimony at trial? Was there testimony from the caseworker or an employee of the hospital that father tried to abscond with the baby?
So not in language that strong, that dad tried to leave prior to baby completing its eat, sleep, and grow protocol or something to that effect, that baby was required to stay 5 days under that protocol. Dad suggested that 4 was enough, tried to leave. There's no testimony that he took the baby and attempted to leave. There's testimony that there's some conversation that occurred. There was a call made to security, and at that point, dad relented in his position.
But there was testimony that security had to be called.
Sure, and if I can sort of understand kind of what's behind your question as well.
That's a dangerous thing when you try to do that with my mind. But go ahead.
Sure, but maybe what's behind your question is, well, what was the effect of admitting these records if there's testimony reflecting what's in them anyway?
What is your prejudice?
Sure, so a couple of things. The trial court did expressly say that these are relevant and admitted and to that extent relied on them. And they are perhaps corroborative of testimony, but I don't think merely cumulative. So for instance, the contents of the record that speak to drug use, mom's positive amphetamines test. Absent that, all there is the caseworker's testimony that mom admitted to her some amphetamine use, so it's better evidence than otherwise exists of a lot of the facts in the complaint. Even if the records are 400 pages and largely don't speak to the issues, there's, like I said, I think corroboration that's not merely cumulative and therefore prejudicial. I think for what it's worth, the trial court didn't engage in a harmlessness analysis. The agency in its own briefing in this case hasn't made a suggestion of harmlessness. So for those reasons, I submit that there was prejudice. Certainly, if nothing else, from the rhetorical effect of trial counsel putting down a 400-page compendium of mom and baby's health history, saying that we've put on testimony about mom using drugs, about dad being disagreeable, and here's this to back that up.
Okay.
So to move on to the court's decision on dependency. The trial court's decision rests essentially on three things. One, that mom and dad didn't engage with the agency in the manner that the agency would have liked prior to removal. Two, that mom has some admitted opioid use. And three, that the parents chose to use powdered rather than liquid formula as their preferred method of infant nutrition. As it relates to engagement with the agency, I think our argument is fairly straightforward. This court has held that non-compliance with caseworker suggestions can't be used to establish the allegations in the agency's complaint.
But doesn't it go more in this case to CSB not getting cooperation even to the point where they could check on the safety of the child being released into the custody of the parents to the home?
So I don't think so, because again, dad being rough, mom being there's not actually much testimony on mom as it relates to that. To the extent there are any conversations about the agency's pre-removal efforts, it's that they made a few phone calls to mom. It's not specified what the caseworker discussed with mom during those. It's not specified what the caseworkers discussed with the nurses in those phone calls. The only testimony about the substance of a conversation between mom and caseworker is after the agency had already made the decision to remove the child. So I don't think there's evidence in the record of mom's non-cooperation to that point.
What about vomit?
I don't know that there's much non-compliance with agency suggestions in the record, and I apologize for not having a transcript in front of me, but certainly he wasn't completely compliant with hospital advice. Again, I would submit that can't be used to establish.
Was there testimony that perhaps some of the issues the child was having was due to withdrawal symptoms that she may have been having because of mother's drug use?
So, to be clear, the only testimony, so the trial court did hold that. The only testimony at trial that suggested what the baby was doing was perhaps indicative of withdrawal was because of withdrawal from mother's prescription of methadone was the testimony.
Would there be a concern, I guess, that father was, I thought in this case there was a bit of a concern that father was placing the child's fussiness just in general and not recognizing this may be a concern of withdrawal symptoms that the child was having based upon mother's, in this case, treatment then, if it wasn't from her specific legal drug use or methadone. Was that a concern that father was not recognizing that these symptoms might be withdrawal symptoms rather than just general fussiness?
So, what I would say is that the transcript is muddled. So there's one of the nurses testified that, well, I don't think this is because of liquid formula. I think this is because of withdrawal from methadone. Another nurse testified babies are just fussy in this way.
But mother did test. She did admit that she had used methamphetamines, right?
Correct.
Okay. Did she test positive for the use of methamphetamines?
So, as part of the hospital records, yes, there's an indication that she was positive for methamphetamine. So as it relates to...
Go ahead.
Sure.
So if you take out every other issue like feeding and the father leaving the hospital, don't we have case law that says ongoing drug use by a parent is something that can be the evidence for dependency?
Your Honor, respectfully, I would submit that the case law says the opposite. A case I probably should have leaned more heavily on in my briefing is in Ray VR. That's 2008 Ohio 1457, and I would submit that is this case. That case involved drug use, opiate use during pregnancy, and there, absent some specific proof of an attendant environmental impact on the child, this court held that that's not subsection C dependency.
But there is environmental evidence, isn't there? The evidence was that the child was going through withdrawal symptoms.
So,
I just want to tell you too, you're in your rebuttal time, so.
okay, just two very quick points on that, and then I'll reserve my time. The testimony, there was nurse testimony, which is not competent to establish a medical diagnosis, that some methadone withdrawal may have been occurring. And again,
Was there an objection when that testimony was made that it wasn't proper medical testimony?
I don't think so. So to the extent like that's an evidentiary concern with that testimony, that would be plain error. However, as it relates to the adequacy of dependency determination, there's language from this court again in Ray OH 2011 Ohio 5632, where the court, as part of its is this sufficient evidence of dependency analysis, said well, there's no qualified medical demonstration of this substance abuse problem connected to an environmental impact. So with that, I would reserve the balance of my time for rebuttal.
May it please the court, Kevin DiMartino on behalf of Summit County Children's Services and Kelly, we are asking that this court affirm the trial court's decision finding that this child was dependent pursuant to 2151.041C. This particular type of dependency finding is based on the condition or environment of the child, and is it sufficient to warrant the state to intervene, assume guardianship in the interest of the child. So with regard to this case, it's important to remember at the time that the referral was made on December 5th, the child had been born on December 1st. The complaint was filed on December 6th. So there's only a couple of days for the agency to have made efforts, as far as reasonable efforts to prevent the removal of the child from the home. Within that few, it's about a day, really, they got the referral December 5th, they filed the complaint on the 6th. In that short amount of time, the agency did contact the hospital to follow through with the referral, with which a referral that a child was born that was substance abuse exposed, that the parents had a long history of drug abuse, that the mother had indicated that she was on methadone, that she had used methamphetamine throughout her pregnancy. She indicated it was her way of dealing with her ADHD. The child did have methadone withdrawal symptoms. The nurse did testify to that, and it is in the medical records. I did not argue that the medical records, if they were admitted inappropriately, was harmless, because I am taking the position that the medical records were properly introduced. They are business records. They are an exception to the hearsay prohibition under 803C. The discussion about authentication was raised to show that the certification was sufficient for those documents to qualify as a medical record. The certification shows that they were created at the hospital in the ordinary course of business by someone who had knowledge of the information, and it was set forth at that time. It's important to remember that the only issue that was preserved at the trial court and here on appeal is whether or not those documents were admissible as, one, relevant, and two, hearsay. There was no argument raised, which they're trying to argue in the reply brief and a little bit here, that there was some confusion about authentication, or maybe they were not properly authenticated. The only issues that was before the trial court was, were the medical records admissible? And clearly they're admissible when you have a referral that relates to the child's health and the mother's health. So was the mother positive for methamphetamine at the time that she gave birth? Was the mother positive for methadone at the time she gave birth? Was this child going through withdrawal symptoms. Those are in the medical records. There's also testimony to support that. In my opinion, if you took the medical records completely out of this case, there is still sufficient evidence for a prospective dependency finding, which is what we're dealing with under 2151.041C. There's also information in the record to show that the reason that we were so concerned about a safety plan for this child is, one, the child is 4 days old. The child has not met the hospital medical protocol for withdrawal, which is 5 days with eating, sleeping, and consoling protocol. So the hospital, a medical professional, had made the determination that this was withdrawal and that the 5-day protocol was in place. There was no objection with regard to that. There was no testimony introduced that the hospital had gotten that determination that this was a withdrawal place that required the 5-day protocol. There's nothing in the record. In the medical records, there is some notation that father was told that the child was sick, fussy, excessive fussing, diarrhea, because of the methadone withdrawal, and that he could go speak to the pediatrician if he disagreed with the protocol. But there was nothing that was introduced at trial. The nurse can certainly testify to, I'm doing my job at the hospital, and I'm doing my job, which was dictated to me by a medical professional, which is to follow the 5-day protocol, and that we told father that part of that protocol is to use a certain type of formula, which the hospital was using as medical treatment for the child who had been in the NICU for about a day and a half after the child was born, exposed to a substance, going through withdrawal. And for the child to get home with her parents, the child had to stop having, right, these symptoms, which is diarrhea, etc., which the nurse explained could be exacerbated by powder. So it was really in not just the child's best interest medically, so the child could be discharged, but also for the parents to be able to have the child to come home, the things that could exacerbate or continue the child to have digestive issues had to be eliminated medically. So there was no, this case is not about parents' rights to determine what type of formula they give their child and whether it should be powder or liquid or tap water or not. The medical basis is the reason why there was an issue. So while the child was in the care of the hospital medically wanted the child to have the formula that would be easiest on the child's digestive system, so we can eliminate the withdrawal symptoms and have the 5 days that the child needed for the child to be able to go home.
So I understand it's the formula issue. I know there's other issues and
It's a small
go on here, but just on the formula issue. The formula, if I understand it, not specifically prescribed for children who are going through withdrawal.
Right.
It is more a concern that's prescribed for children that are having digestive issues, for want of a better term, and the nurses and doctors felt this would be better for the child than the other formula, just because of those particular issues.
That, and they indicate that powder should not be used for a child under the age of 2 months. But that was not, that's in the record, that is not the issue here. The issue here is that this child is having these issues, right, that are including the digestive issues. We know that powder can exacerbate that. So they want and they want to know what the child is consuming so they can eliminate other issues. I mean, anytime you're a patient in a hospital, you're going to have to do the things that the hospital wants you to do, or you're going to be against medical advice. And when you're trying to get discharged, you have to do the things that the medical professionals want you to do so you can get discharged, unless you're going to be discharged against medical advice. So this is a situation where you've got a child that's just a couple of days old, is having these issues, which the medical testimony from the nurse, as well as what's in the medical record, was that it was due to the methadone withdrawal, and that this formula, to answer your question, yes, it can make that continue and to have the child continue to have symptoms, which could have, of course, delayed the child from being discharged. So in that very short window, that one day, the agency did attempt to talk to the parents, and on page 42 and 43 of the transcript, it's reflected that the parents were not willing to meet with the agency and were not willing to do a team decision meeting. This is a family that has had involvement with the agency before. Mother has had 2 other children removed from the home. So when you take everything together, the fact that the mother does have ongoing illegal drug use issues that she continued to use during the pregnancy, which impacted the health of the child, and the family is not being cooperative in allowing the agency to assess what potential condition or environment awaits this child once the child is going to be discharged, in all likelihood the following day, because that would have been the 5th day of the protocol, assuming that all the benchmarks were having been met. That put the agency in a position where, considering the totality of the circumstances, we had to assume guardianship to make sure that once this child was released from the hospital, that all of the things that needed to be in place for the child's health were there. And
Counsel,
the
can I interrupt you just for a
Yes.
second? I want to make sure about something. You keep on talking about withdrawal from methadone. Was there any allegation that the child was withdrawing from methamphetamine drink?
It specifically says in the transcript methadone.
Okay, let me ask you this then. Methadone was prescribed as a treatment. Can we use that against a parent?
We can say that the child, we're not using it against the parent, we're using it for the condition of the environment of the child. So whether it was, no matter what the drug was, the child was born having withdrawal symptoms from. The fact was that the child, because of the exposure to that medication, had withdrawal symptoms that required medical treatment and attention. And father wanted to take the child out of the hospital, 1, before the protocol for withdrawal was met, and 2, did not want to follow through with the medical things that would help that child get through the protocol. So frankly, it's clearly awful that mother was using methadone, right, and that this child had any type of exposure, but I'm not saying that mother is to be punished or at fault for trying to get over her fentanyl addiction by taking methadone, but it did have a consequence on the child that necessitated that child to be in the NICU and then to be under a 5-day protocol to get healthy enough to be discharged.
And was the evidence that the parents brought in the powdered formula to the hospital?
The evidence that it would have had to come from father for that powder to be used in the hospital because the hospital did not use it. There was also some testimony that father had used tap water, which can have bacteria. So while all of those things, once and he refused the education piece too. So, once the child was medically cleared, if they went home and they wanted to take, I don't want to, say it kind of cavalierly, but take the chances with tap water potentially having bacteria, or take the chance of the powder having, digestive issues on the child, that is a decision, right, in theory they could have made after the child was medically cleared. But what we're talking about is the child is still having withdrawal symptoms, and the powder formula medically is something that's going to further cause issues with that and potentially cause the child to not be able to reach that benchmark of eating, sleeping, and consoling properly within the 5 days. And then on top of the fact that we can't get they wouldn't agree to a safety plan, they wouldn't let us assist the child's conditions, and that they wouldn't meet with the agency when there's been, prior involvement with the family. Those are sufficient for prospective finding of dependency under 2151.041C. And the efforts that the agency made in that very short amount of time were reasonable efforts designed to prevent the removal of the child from the home.
What were the requests in the safety plan, pardon my interruption? What did you want the parent to do in the safety plan?
The record does not reflect what the safety plan was. It just said we had one, we wanted to talk to the parents about it, and they refused. And that's probably why it's not in the record.
So it got no further than, we want to talk to you, they said no, and that was all the further the evidence was.
Right, and I think that makes sense with the tiny window of time that we have, and you've got a child that's still in the hospital and parents that are understandably frustrated and upset. But to say that the agency could have or should have done more it's really unfair in that short window of time. We're talking about less than a day.
In the state's brief, it says that mother had a warrant for her arrest at the time. How does that play into this as well?
That was in the complaint. It did not, that I recall, come up in the journal entry finding of dependency. So if she had a valid warrant at the time of the complaint, it would have been still valid because it was only a day later. But I don't recall the testimony that was presented, and it was not an issue in the journal entry. I apologize, Your Honor.
No question.
Okay, sorry. So if there's nothing further, I would ask that this court find that there is sufficient evidence in the record, as well as the greater weight of the evidence shows that this child was a dependent child pursuant to 2151.041C, that the medical records were admissible in this case because there were allegations not just of a dependency, but also of abuse. And even though there was no finding of abuse, the agency was still required to put on evidence that would go to abuse. Certainly medical records relating to a mother and a child with regard to the conditions of both of those people, as far as if they're positive for any type of medication, whether or not the child had withdrawal symptoms, what the course of treatment was for that withdrawal, all of those things would be relevant, and based on that, we would ask the court to affirm. Thank you.
You have about 4 minutes for rebuttal.
Thank you, Your Honor. I suppose the overarching theme of what I have to say in the rebuttal is that I would just encourage the court to take a careful look at the record and the testimony in this case. I submit that it is not the case that the counseling to use liquid rather than powdered formula was in the testimony, in the medical records, in any way linked to the child's stay in the NICU, the purported withdrawal diagnosis. I would encourage the court to take a hard look at where withdrawal comes up in the testimony. It was in one, sort of passing reference by the second nurse, that is Nurse Vasco, the transcript 27 to 28, where she suggested that methadone withdrawal rather than formula was what was causing the baby's fussiness. There was no suggestion that, to my recollection, that the baby's being placed on this protocol was related to withdrawal. I mean, the baby was born underweight. That prompted its initial stay in the NICU. It graduated from the NICU to an ordinary maternity ward and was on a gain and growth protocol to leave for reasons related to weight. As it relates to counsel's argument on the reasonable efforts issue, just briefly, it's not exactly our point that there are Herculean efforts the agency has to undertake in a circumstance like this where the removal is occurring shortly after birth at a hospital. But the agency does have a burden of demonstrating what reasonable efforts it took at a hearing, at every dependency hearing, but certainly at adjudication. And that is their burden. And in this case, there just wasn't an articulation of, to your point, Your Honor, what was in this safety plan. What the purpose of the team decision making would have been, like what issues would have been raised in the safety plan. What the substance of the conversations between the caseworker and hospital workers were. So it's not just that the agency could or should have done something to prevent removal in the sense that it's usually talked about, further along in a dependency proceeding, like in a disposition or a sunset disposition. It's that they just didn't carry the burden of having made any analysis of, what the alternatives to removal were at the time that they made the decision to remove the child. And unless the panel has questions, I think I would rest on the basis of my brief there.
Any questions?
No.
Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. The opinions are also posted on the Ohio Supreme Court website. Thank you again.